Today I'd like to take the opportunity to talk to you just a little bit about the role of the county court judge in criminal proceedings. As you may know, the most serious crimes we refer to as felonies. Felonies are generally prosecuted at the county court level. And in order for a case on any level, but particularly in county court, there are three very important and significant players. You have the prosecutor, who represents the people, and you have the defense attorney, who represents the accused, and you have the judge. Now, county court and the felonies that come before the court generally follow a very standard pattern. That is, the criminal procedure law in New York dictates how a case is supposed to progress. Typically, there's an initial appearance, what we call an arraignment, where the defendant is read and advised of all of his constitutional rights, the rights that you and I cherish. After the initial appearance, the attorneys go through a phase we sometimes refer to as discovery. And during that phase, the defense attorney and the prosecutor exchange information and evidence, because no one should ever have to go through a criminal proceeding, much less a trial, without being fully advised of everything that is against he or she. Once you get through the discovery process, you then enter the phase where the judge, the prosecutor, and the defense attorney look at all of the relevant factors in the case in the hope that maybe the case can resolve itself without the need for trial. And what I mean by the factors, you look at who the defendant is, whether that defendant has a lengthy criminal record or no criminal record. You not only look at the bad things that person has done in their life, but you also look at the good things they've done. And all of that has to be factored in to determine what is the appropriate sentence. Each case needs to be analyzed and scrutinized on the individual facts, the individual merits, and the background of the individual defendant. If at the end of the day they're not able to reach an agreement, the case is scheduled for trial. And of course, each defendant at that level has the right to have a jury hear the case or to have a judge hear the case. In either event, at the end of that trial, if the accused is found guilty, the judge then ultimately sentences the defendant. So then the question becomes, why or what background do I, Frank Revoir, have to be a fair and impartial judge? Well, I'm here to tell you today that, if you don't know, I have 21 years of experience in the criminal law arena. I started my legal career as a law clerk to this county court that I'm seeking to be elected to. Back when I graduated from law school, the Honorable Kevin M. Dowd was the county court judge, and I served as his law clerk for the first 5 years of my career. After that, I opened my own private law practice, and I have practiced criminal defense work representing individuals accused of committing everything from traffic tickets to felonies. In addition to that, for the last almost 13 years, I've also served as a part-time prosecutor with the county attorney's office. My job as a prosecutor has been to prosecute juvenile delinquents. That is, individuals under the age of 16 who commit acts which would otherwise constitute a crime if committed by an adult. And I think that's very important, because in order to be an effective judge, that you need the background from all different sides. I have the prosecutorial background, I have the defense background, and I've also worked in this very court as, for lack of a better phrase, the right-hand man to the judge. I've done the legal research, sat through hundreds of trials, and I believe that my entire experience could be characterized as comprehensive. And like I've been saying in this campaign, this is a comprehensive judgeship, and I'm the comprehensive candidate. I have the background to handle the criminal aspect of being the next Chenango County Court judge. Thank you.